major setback or a step forward? The Supreme Court's decision on Montana's abortion consent law. In an important turn of events, the Supreme Court on Thursday opted not to examine a Montana statute that mandates individuals under the age of 18 to secure parental consent before they can have an abortion. This decision effectively upheld a previous ruling from the state courts that had invalidated the law. But what exactly does this law entail? Enacted in 2013, Montana's legislation prevents doctors from performing an abortion on a patient under 18 and without obtaining written consent from a parent authenticated by a notary. The contention arose when Montana's highest court determined that this law clashed with the state constitution, which provides more extensive abortion protections compared to the federal constitution. And this is where things get interesting. While the Supreme Court chose not to provide an explanation for its decision, two conservative justices, Samuel Alito and Clarence Thomas, outlined that the technicalities surrounding the case made it unsuitable for addressing the bigger constitutional questions. They also emphasized that this denial should not be interpreted as dismissing the central arguments of the appeal, a point of contention. Montana argued before the Supreme Court that parents have the right to make medical decisions for their children because they are presumed to act in their child's best interest, and it is vital that the state respects this private family domain. But what does this obscure? On the other hand, Planned Parenthood emphasized that the discussion hinges more on the protections within the state constitution rather than solely on the rights of parents. They contended that Montana's view doesn't fully account for other fundamental rights, such as a minor's autonomy concerning medical choices. Once again, Montana's statute, although never implemented, carried penalties including fines and imprisonment for physicians who bypassed the need for parental consent. Importantly, the law did offer an option for a minor to challenge the consent requirement by showing mental maturity in court. Looking back at history, in the 1970s, the Supreme Court addressed a comparable issue shortly after the landmark Roe v. Wade decision in 1973, in a case known as Planned Parenthood of Central Missouri versus Danforth. The court invalidated similar parental consent provisions, highlighting the constitutional right to abortion established by Roe. Additionally, in 1979, the court struck down a Massachusetts law that did not provide a judicial bypass for minors seeking an abortion. An evolving landscape. With the Supreme Court's recent decision in Dobbs v. Jackson Women's Health Organization, which overturned Roe v. Wade, the focuses on state rights and constitutional interpretations have shifted. Montana argued that the recent ruling gave stronger support for its measures by highlighting that states can enforce certain rights absent from federal constraints. The broader implications. Montana claimed that the state high court's decision undermined parental rights by suggesting that parents' federal rights don't extend to knowing and influencing their child's critical medical decisions, particularly on the matter of abortion. So what do you think? This decision from the Supreme Court and its implications are bound to stir a variety of opinions. Do you agree with the Supreme Court's handling of the Montana case? Is parental consent a fundamental right, or do the rights of minors to make health decisions carry more weight? Share your thoughts and join the conversation below.